Hi folks, and welcome back to Contract Law. This is video 6 in the video series for contents of a contract and exclusions. And you will recall that we need to finish off our discussions of incorporated terms. And if you think back to video 5, we started off our discussion of terms incorporated into the contract by looking at terms incorporated by way of signature. So there's something floating out there, a document of some description that has been signed. The question is, does that form part of the main body of contract terms or not? And now we need to fast forward to terms incorporated into the contract by way of unsigned documents. Now they've still got to have some kind of contractual significance here, obviously, otherwise they can't make it into the contract as a term. But this is the true home, I think anyway, of the whole discussion about incorporated terms, the notion of incorporating a term by way of notice. This is where many of those nasty little beasties, those exclusion clauses, will live in documents or signs that purport to include the term other than by way of signed agreement. There's a couple of ways to incorporate by notice. Firstly, where documents are exchanged. So obviously there's some kind of written terms are passed backwards or forwards between the parties. They're not outwardly obviously contractual in the sense of being signed by the parties, but nevertheless there's been some kind of exchange. They're the ticket cases. The other way to incorporate by notice is where documents are not exchanged at all. So you might have terms brought into the contract by way of signs, websites, even a prior course of dealing. And they're generally speaking the signs cases. Okay, so that's the lie of the land, where we're headed in this video. In terms of the ticket cases, what you need to do is kind of take stock of where we are. It's one thing to say that a term is incorporated into the contract because it is part of the main body of contract terms and it's been signed off by the parties. So the whole Lestrange and Gorka scenario, obviously the term is incorporated into the bargain at that point. But then we saw, that step away. You might have documents that were signed by the parties and yet, they don't form part of the main body of contract terms. Can you include them then? We saw that it's kind of easier to get around the incorporation issue there because sometimes those documents might be signed after the contract's already happened. You might find other things have complicated the scenario, like misrepresentation or non-est factum and so forth. Then we kind of take another step away when we're talking about the tickets cases because you haven't got any signed exchange of documents at all. You've just got an exchange of documents. So you haven't got that rather important signature on the dotted line. So as I said before in the other video, the signature is a very important undertaking and it shows that the party has assented to the term. So here we've kind of stepped away from the Lestrange and Gorka scenario, one step towards those extra contractual signed documents that we were talking about in the last video, and now we're talking about unsigned documents at all. There's just been an exchange and we still want to incorporate that as a term of the contract. So I've laboured that point a little bit, but the reason is that you have to be crystal clear on the fact that the parties, in order to be bound by terms on tickets and unsigned documents, will still need to have sufficient notice, okay? The onus of proving sufficient notice is on the party seeking to rely on the term, and that will always be a question of fact. If the document is of a type that normally contains contractual terms, generally speaking, you'll be bound if you don't object or enter into some kind of discussion about the terms, okay? The reasonableness is in the context. If that document that's been given to you is of a class of documents that normally has contract terms on it and you just take it, you don't object, then it's reasonable to assume that you have assented. In the Mendelsohn and Norman case, and one of quite a number of car parking cases, there was a ticket that was given and the usual exclusion clause on the ticket, excluding liability for losses. The person parking their car was going to lock the car. The parking attendant said, no, don't worry about it. I'll get in, I'll park your car for you, and we'll do it that way. And the car owner said, well, I really want to make sure that you lock the car because there's valuables in there. You can imagine what happened. They forgot to lock the car. The valuables got stolen. The issue there was that they were bound by the exclusion clause on the parking ticket because no objection was made. The ticket was of a kind of document that normally contained contract provisions, and because that was the case, the exclusion clause was in the contract and governed the bargain between the parties. I have put up the little bubble just before, drawing your attention to the fact that, generally speaking, where you're talking about offer and acceptance, the offeror can't stipulate that the other party accept their terms by mere silence. And you're thinking to yourself, hang on a minute, how does this work? Because it seems to be a little bit like that. Generally speaking, notwithstanding, it seems like a little bit of a hiccup in contract law principle, you will normally be bound by an unsigned document that has been exchanged if you don't object or discuss the terms. So that is the Mendelsohn case. However, the thing that we need to very quickly follow on with is that you will not be bound if that document that does contain the contractual terms has some form of harsh, unexpected, unusual term in it. If that's the case, then whether or not the harsh or unusual term is included as a contract term will depend on the steps that were taken by the party that wants to enforce that term in drawing that term to the party that's meant to be bound by it, drawing their attention to it. So the pinnacle of actually drawing someone's attention to a term would be asking them to read the term. If that's the case, even if it's a harsh or otherwise kind of unreasonable term, you may stand some chance of it being enforced. But as they said in Parkland South Eastern Railway Company, short of that, if it's something unexpected, unreasonable, disproportionate, harsh, then you're probably going to have to ask them to actually go ahead and read the thing. The last thing I want to say in terms of the reasonableness of steps taken is that if you do fall on the happy side of having taken sufficiently reasonable steps to draw a party's attention to the content of a term, it won't matter if a particular party is left unaware of the content of the term because of exceptional ignorance or stupidity or carelessness.
Are you crazy? Or just plain stupid?
Stupid as stupid does, Mrs. Blue.
Okay, the fact is you've taken the reasonable steps and you're protected. The term will stand as incorporated into the contract between the parties. That can have some harsh results. So in the Thompson case, we had a party that was had suffered some personal injury. She couldn't claim against the railway company because of an exclusion clause. How was the exclusion clause brought into the contract? The ticket that the plaintiff got said on its face, for conditions C back. If you flipped it over and you looked at the conditions on the back, it said that the contract was subject to the company timetables. If you bothered to go and have a look at the company timetable, you would find that contained the exclusion that was at issue in that particular case. We call that incorporation by reference. where she's had to go and look at the timetable to find out the rest of the bits and pieces that she needed to know. Obviously, because she couldn't read, she wasn't actually made aware of the content of these terms. Nevertheless, despite the circuitous nature of incorporation by reference and having to go and look here and do that, this and that, it was, in that case, held reasonable to draw parties' attention to the content of the term in that fashion. The other thing I think that weighed on the court's mind there was that the ticket price was very cheap, and so you kind of would be on notice thinking, hang on, is there some catch to this bargain? So that was the Thompson case. Of course, the flip side to all of this is that if the document that contains the term in question is not of a kind that would usually contain contract terms, then more than likely you won't be bound by the term. It won't be incorporated into the contract between the parties. The Chapelton case was an instance of that. We had another personal injury case. I've said that he was wrecked from the deck chair. It was a case of personal injury, but we had an exclusion clause on a receipt. So as the plaintiff hired the deck chair, he was given the receipt. The receipt contained the inevitable exclusion clause. The plaintiff suffered the personal injury, and the hirer purported to rely on the exclusion clause, couldn't do so. Why is that? Receipts aren't normally something you would look at carefully to find contract terms. Causer and Brown, just another kind of instance of that. There was an exclusion clause on a dry cleaning docket, found not to be a term. In this kind of scenario, you haven't got the reasonableness of the context underneath you to protect you. So, because the document is of a kind that doesn't normally contain contract terms, then you'd have to have actual notice or some pretty careful, reasonable steps being taken to bring the clause to the recipient's attention. Perhaps you might have one of Lord Denning's red hands there. Again, the onus is going to be on the defendant to show that the document was, in fact, delivered as a contractual document, not a voucher or a receipt. So they are the ticket cases. And then, if we plunge forth, you will see in the text a number of cases which are kind of just more examples of the same, except in a different context, if you will. Instead of having documents exchanged by way of tickets, you have no document at all being exchanged, and you have the term being brought in via a sign. So we've come a long, long way from Mrs. Lestrange, haven't we? So we've come from Lestrange and Gorka, where you've got incorporation by signature in the actual main body of the contract. Then you've got the cases that looked at whether or not you could incorporate a term where it has been signed off but not in the body of the main contract. And then we had a little look at unsigned documents, the ticket cases, and now we've kind of come as far away as you can from Lestrange and Gorka, and we are looking at the sign cases. Similar principles, as I said, apply here as in the ticketing cases, really. Balmain, New Ferry, I have to say this is one of my favourite contract cases. Just goes to show the kinds of things that were litigated back in the day. But dear old Mr. Robertson, he had seen a notice over the entrance to a private wharf. You had to pay a fare of 1 penny to get onto the wharf. You had to pay the fare through the slot in the turnstile. You can then proceed onto the wharf. Now, the notice said that every time you went onto or left the wharf, you had to pay your penny. Robertson ended up paying his penny, got onto the wharf, and then realised he'd missed the ferry. Unfortunately, he then tried to leave without paying his penny to disembark from the wharf. There was a bit of a tussle that ensued, and he was actually physically prevented from leaving without paying his penny. He then turned around and sued for, amongst other things, assault and false imprisonment. It was held in that case that the actions of those people that prevented him from leaving without paying his penny were justifiable because of Mr. Robertson's breach of contract. They said he certainly had sufficient notice here, even if it was his first time on the wharf. The notice was quite prominent in terms of drawing reasonable attention to the terms that were on the notice and the requirement to pay your penny when you got onto and left the wharf. And the thing about Mr. Robertson, though, is that he had been on the wharf before. He did know about the notice. He was aware of the turnstile and the terms. He just didn't want to pay his penny to get off the wharf. He was pretty ticked off about having missed his boat, and he didn't want to then, on top of all that, have to pay another penny to get off the wharf. So the prior course of dealing also established that he'd had reasonable notice of the contents of this particular sign and the terms that were on the sign. Folly in Marlborough Court is just one further example of that rather classic contract law case, this one, where a notice was placed up on the wall of a bedroom in a hotel, and it didn't really matter how big the writing was on the notice or where exactly in the room it was displayed, because the fact was the contract had been formed at the front desk where there had been the exchange of money and terms and so forth. It was too late to try and incorporate terms via a sign on the wall there. The same kinds of principles will then also translate into things like notices on websites. It will really all depend on how much notice and what steps have been taken to provide that notice to the party that's intended to be bound by the contractual term. You know yourself, you scroll through websites and you don't really read 90% of what you see. However, there is case law that shows that if you've been directed by the website to click on terms like I agree or tick a box to say that you've read terms, in that kind of scenario you're more than likely going to be bound by the terms. But where there's been a failure to draw notice by means of those kinds of steps being taken, it may well be that notice is just placed on a website in a passive manner, probably won't incorporate terms into a contract. So there's growing case law in that area as well. Same kinds of principles as we have been discussing, and they are the sign cases. And this is the end of the topic of incorporated terms. So the next thing to consider is what else should be in the contract that is not otherwise apparent from the verbal agreement or the written agreement. What kind of terms might be implied into a contract? And that'll be video 7. But until then, bye for now, guys.